Hey, we are Group 9 CBI Cybercrime Investigators in IST 432, fall of 2017. In this course, we examine the legal and regulatory environment of information technology, varying from subjects of intellectual property, privacy, political issues, and e-commerce. Our group members include Seth Marasco, Selena Orban, Laura Daly, Hannah Broadwell, Maurice Saunders, and James McGegrin. Our research question asks, what is the significance of the Equifax breach and how does it relate to cybercrime?
In September of 2017, Equifax, a credit reporting company, revealed that they experienced an extreme cybersecurity breach that compromised sensitive information of millions of Americans. Equifax is one of the largest credit reporting agencies in the U.S., making it an attractive target to hackers. The breach took place from May to July 2017. Equifax reported that they believe roughly 143 million Americans have been affected by the breach. The types of information that was stolen include social security numbers, dates of birth, names, addresses, and driver's license numbers. On top of this, 209,000 Americans' credit card numbers were stolen. Although the breach began in May, Equifax did not become aware of it until July 29, 2017. Executives at Equifax sold $1.8 million of Equifax stock almost immediately after they found the breach. What makes this breach so frightening, though, is that many of the affected 143 million people do not know that they have been affected. This is because Equifax receives much of its information from banks and credit card companies.
Although laws have been proposed, there is not yet any federal law that regulates data breach notification. Right now, regulation and notification is left up to the states and varies across the country. Only 48 states have data breach notification laws at all, and only 8 specify a timeline for which the consumer needs to be notified within. The timelines vary between these states, ranging from 15 to 90 days in comparison to the European Union law that requires notification within 72 hours of discovering a breach. As Equifax is based in Georgia, the law that was relevant in requiring Equifax to notify their customers was the Georgia Personal Identity Protection Act. This law requires that the company notifies their customers if any of their personal information, including social security numbers, credit card numbers, or account passwords have been compromised. Although they were required to notify their customers, there was no timeline set up that they had to follow. This means that Equifax could have taken as long as they wanted to notify their customers that their information may have been accessed. As customers of Equifax span the country, breach laws from other states will also be applied in the Equifax case, since some of the victims were residents from other states. Residents from across the country in states including California, Georgia, New York, Washington, and Illinois have begun to file class action suits against Equifax. Breach laws in California are stricter than the rest of the United States, requiring notification immediately after discovery, and under the California breach notification statute, they can be held liable using general negligence theory if they do not notify.
As Equifax is classified as a financial institution, it is required by Gramm-Leach-Bliley Act of 1999 to safeguard the private information of their customers. According to the Congressional Research Service, the act requires financial institutions to provide customers with notice of their privacy policies and require financial institutions to safeguard the security and confidentiality of customer information, to protect against any anticipated threats or hazards to the security or integrity of such records, and to protect against unauthorized access to or use of such records or information which could result in substantial harm or inconvenience to any customer. There is also the FTC rule, which applies to all businesses that are involved in any financial services. This rule requires these businesses to have an information security plan. With this rule, actions are able to be taken when a business fails to protect personal information. The Equifax breach is a prime example of a customer being used to enhance an existing crime. Identity theft exists long before the internet did, but never on the scale that it is on today, due to the development of the internet.
The Equifax breach relates to cybercrime law due to the nature of the information stolen by the hackers through the use of a computer. The sensitive personal information has led to cases of identity theft by the hackers and could potentially lead to many more instances. As of early November, there have been over 240 class action lawsuits filed against Equifax since the breach was disclosed in early September. Many of these cases have been filed across the United States, including the federal courts of California, Georgia, Illinois, and New York. Specifically, these states have accused Equifax of breaching the U.S. Fair Credit Reporting Act. The law is put into place to ensure the accuracy and privacy of the information provided by credit reporting agencies. A case filed in Illinois argued that Equifax delayed in telling customers about the breach. This led to customers not having the opportunity to address the potential fraud in a timely manner or take advantage of the remedies under the FCRA, further discouraged their information from circulating online. The federal court in California argues that Equifax knew and should have known about the inefficiency of its data security because of the previous breaches that occurred in 2013 and 2016. Another lawsuit filed in the federal court of California focused on Trusted ID, which is a credit monitoring system that is offered free for a year by Equifax to its customers. Equifax failed to tell its customers that it owned Trusted ID, whose business model relies on encouraging customers to give up their personally identifiable information. California courts argued that Equifax traded protecting its customers' information for a money-making opportunity. Another problem surrounding Trusted ID is located in the terms of use. Customers who signed up for Trusted ID and agreed to the terms waived their rights to pursue class action lawsuits. Instead of the customers would have to pursue legal action through arbitration, which leads to a binding decision. After much criticism, Equifax updated its policy on September 11th to reflect its customers' rights to take legal action. Customers' personally identifiable information gained from this credit monitoring system can be held by hackers for years to come. Furthermore, a lawsuit filed in Seattle, Washington has alleged that Equifax willingly and negligently allowed hackers the opportunity to access their customers' personally identifiable information. Specifically, the lawsuit argues that under state and federal law, it was unfair of Equifax to create the illusion that customers would benefit from Trusted ID. As a result, many of the lawsuits in states across the United States are making similar arguments about Equifax and its lack of security measures to protect customer information.